So good afternoon, everyone. Welcome to the Strigberger Brown Armstrong Lunch and Learn webinar series. My name is Lisa Armstrong, and I'm the managing partner here at SBA. I've been practicing insurance defense my entire career, and I specialize in complex auto claims, both first and third party, as well as other types of first party claims like cyber claims. For those of you who are unfamiliar with SBA, we are an insurance defense law firm with 20 lawyers in 3 offices across Ontario. We have a number of different practice groups, including auto, CGL, property, subrogation, D&O, E&O, and cyber. So for today's webinar topic, the topic is negotiating tips for adjusters. If you have any questions during today's presentation, you can put them in the Q&A and I'll try to get to them at the end of the presentation. Alternatively, you can email me questions or request the slide deck and I'll get back to you. This webinar will also be posted on our website and our YouTube channel within a few days. And if you have missed any of our previous webinars, you will find them there as well. So as they say, negotiation is an art, not a science, and therefore each one will be a little different. I'm going to start today by discussing preparation for settlement discussions and some of the factors that you should consider before starting negotiations. And then I will go through 5 tips to keep in mind while you're negotiating settlements. So preparation. Most importantly, you need to know your file. Sometimes settlement discussions can arise unexpectedly in an email or in a phone call, but before you start those discussions, be sure that you know what is in dispute. You know what the strengths and the weaknesses of your evidence and your position are, that you know the claimant's current status and what, if anything, is outstanding. And on AB claims specifically, you should look at the overall and the recent burn rates as well. Then you should use all of this information to do a fair and accurate exposure analysis. As I'll discuss in tip number 3, you can blow a good opportunity for settlement if you have not done a fair and accurate exposure analysis before making your first offer. Knowing the file will help you identify and rely on the strengths of your file and your position, and avoid weakening your negotiation position by relying on weak or unpersuasive evidence, or highly controversial evidence in some cases. There are several factors that can also affect the tenor of negotiations, the motivation to settle, how settlement discussions fit into sort of the overall handling of the claim. So for example, negotiations could happen very informally, like I said, in an email or on a phone call, but they can also happen at a court-mandated proceeding, like a case conference or a pretrial, or at a private mediation where the whole purpose of the meeting is to discuss settlement. Settlement discussions can also happen at different stages in the claims process, meaning before there's a dispute, before, after your discovery, when you receive a LAD application. And so in addition to knowing your file, you need to consider the effects of these types of factors, because whether or not you realize it, they're going to affect your negotiations. Finally, in preparation for settlement discussions, you need to consider your audience and think about their goals and needs from a negotiated resolution. So this can be easy if you're dealing directly, or relatively easy if you're dealing directly with the plaintiff or the claimant. But when you are dealing with an intermediary, such as a lawyer or a paralegal, this adds a whole nother set of goals into the mix. And when you add a judge, an adjudicator, or a mediator to that mix, or other parties, it can get even more complicated. But the goals and the needs of the parties, including your company's goals, are really what drive mediation. So I know I said that the most important thing is to know your file, and that remains true. But the last sort of preliminary note I want to make is that settlement discussions themselves should not be overly focused on the issues in dispute. So while there might be situations where obviously you need to clearly state a position on an issue, like you have a non-negotiable MIG position or a non-negotiable threshold position, generally you should be focusing on the goals and the needs of the parties to the negotiation, such as giving the plaintiff or the claimant control over treatment, allowing them to move on, avoiding further assessments, or avoiding the uncertainty or cost of trial or a hearing. Consider just a very simple example. So AB claimant has submitted a treatment plan for a hot tub. It's been denied as not reasonable and necessary. However, they are continuing to attend physiotherapy and massage therapy, and you're currently approving it. Ultimately, what they want is a hot tub instead of continuing facility-based treatment. You want a closed file. So understanding this motivation doesn't change your exposure analysis. If you feel that you have a strong denial on the hot tub, I'm not suggesting that you offer to pay for it. But if discussions get too focused on whether or not that hot tub is reasonable and necessary, the parties might miss the opportunity to reach the win-win resolution of the file. So if instead you focus on getting the med rehab funds into the claimant's hands so that they can direct their use, this matter would seem very likely to resolve because it accomplishes the insurer's goal of resolving the claim within the range of their med rehab exposure that you have with regards to the physiotherapy and the massage therapy, and it accomplishes the claimant's goal of getting a hot tub. Or having the funds to get a hot tub. So let's assume that you've done your prep and you're ready to negotiate. So let's move on to the tips. So tip number one, always get an offer or a proposal from the party making the claim. There are many reasons why the plaintiff or the claimant should make the first offer, primarily because it's their claim. So they need to set out what they want. And if you go to a pretrial or a case conference, the judge or adjudicator is always going to request the first number from the moving party, unless they've already made an offer. Lawyers know this. And so if opposing counsel is trying to force you to make the first offer, they're simply trying to take your advantage as the defendant. So why is it an advantage to get the first offer? It provides you with a framework, first of all, for the negotiations. So even if it is completely unrealistic, it does provide a ceiling for the current negotiations and sets out what is being sought. Sometimes you are pleasantly surprised. The offer might be in the range that you assess the file at, or even in some cases, it could be less than what you were prepared to pay. So it can really speed up the negotiations. But the main advantage is that the first offer gives you information. It identifies the heads of damage the claimant or plaintiff is seeking and what is important to them. Particularly if you're able to get a breakdown of the offer or their position on the heads of damages. At a minimum, even if negotiations fall apart, you will have gained valuable additional information that you can consider, you can explore and investigate, or be prepared for should the matter move into dispute. Practically speaking, requiring a proposal from plaintiff's counsel also forces counsel to turn their mind to the file, which is half the battle in getting many claims settled. Of course, the exception to this rule, which I've noted on the slide, may be that if you are dealing with an unrepresented plaintiff or an unrepresented applicant, you may need to make the first offer and explain your rationale to avoid getting a completely unrealistic offer from them. That will be a bit of a judgment call. Tip number 2, never bid against yourself. You will get counsel who will reject your offer outright without making a counter offer, or even ask you to make another offer, taking something else into consideration that you hadn't thought of, or that they think you haven't considered. You should never bid against yourself by making 2 offers in a row. Instead, you should ask them to make a counteroffer, letting them know that you'll take the new information into account in your next offer. Remember that the goal of mediation is to bridge the gap between your positions. So every move that you make brings you closer to the plaintiff or the claimant's number, and vice versa. If you've made an offer and opposing counsel or the opposing party is unable or unwilling to give you another offer, it's telling you something. Either they're at their final number for the time being, or this is just a power move to try to shrink that gap by getting you to move closer to their number without reciprocating. Tip number 3. Avoid extremes and understand that negotiations can take time. So starting too low or too high can end or stall negotiations. The fact is that negotiating can take time. And I know that's not what you want to hear. You're all very busy and you want to figure out if you can get this claim settled or not, so you can decide what to do to move this claim forward, as well as to return to working on the other matters that are on your desk. And certainly in some case, a short timeline can force the parties to be more efficient, but sometimes it just results in numbers getting thrown out there. And while I encourage all negotiation efforts, there are risks when you start too high in order to try to speed the process up. So starting too high or too close to your final number may not give you enough room to actually negotiate. It often takes counsel and or the claimant or plaintiff time to adjust their expectation if the settlement range is significantly lower than what they expected. Sometimes this involves a number of back and forths until the differential between the offers can become acceptable to them. Obviously, the bigger the initial gap, the more time it might take to reach a compromise. My advice is don't give up too soon and do not rush the process, because it is just that, it's a process, and adjusting your expectations and moving away from your best case scenario for either of the parties can take time. For those of you who have attended global mediations, I'm sure you will have noticed how slow things move, and also how the time sort of factors into the negotiation process. That needs to happen when you are mediating claims directly with the claimant or counsel as well. So I chose the picture on this slide intentionally. I think of negotiating a settlement sort of like trying to convince a person who is afraid of heights to bungee jump. So they're standing on a bridge, they're all hooked up. They have agreed to jump for $50,000, and you've asked them if they'll jump for $10,000, which they have flatly rejected. At this point, you're basically beginning the process of identifying the lowest number in between, which would get them to take that leap. So if you offer $30,000 right away, they would likely reject it because they have not adjusted their expectations down from 50,000. But if you are at 27,000 and they're at 32,000, after some back and forth, it's going to be a lot easier for them to move to $30,000. So it is the process of getting to 27,000 and 32,000 that can take some time. Alternatively, if you start too low, you can prevent plaintiff's counsel or the plaintiff or claimant themselves from engaging in the negotiations. So they end before you even get started. It also suggests a lack of foundation or principle to your offer, which really brings me to my next tip. So tip number 4 is start with a principled number. By principled, I mean 2 things. So first and foremost, your offer needs to be a number that you can explain. Secondly, people often negotiate using round numbers, giving the impression that the number is somewhat arbitrary. I like to use precise and principled numbers, particularly for the first offer. So again, using a very simple example, if you're trying to settle a meds only AB claim and the only treatment that the claimant currently continues to receive is physiotherapy once a week, you might consider making an offer of $5,187. That's the physiotherapy rate of $99.75 times 52, as opposed to rounding it to $5,000, which might seem arbitrary. It would also be principled to start with an offer of half that amount. I'm not suggesting that if there's a year left on the claim, a principled offer is to pay for the remainder of the policy period. But at 50%, you would still be at $2,593.50, like an uneven amount, with a message to them that another year of treatment may not be necessary, or the frequency should reduce over time. But it is a number that you can support on a principled basis, even if the claimant's proposal has asked for 4 different types of treatment, a gym membership, and a number of assistive devices. The same is true on large files. In fact, I would say you are more likely to get called out by experienced counsel for being unprincipled on a higher exposure file if you use numbers that you can't support. So you will lose credibility and trust if you make an offer that you can't provide a rationale for. It's even more common to work with round numbers when discussing settlement of tort files, because there's just not as much structure as there is in the AB environment. But I encourage you to use the same approach on your first numbers. Make it clear that your offer isn't arbitrary, and that you have done the math and factored in costs and PGI, which don't come out to even numbers. So while I encourage you to negotiate with numbers that you can explain, and I would generally avoid breaking down your offers. Instead, I recommend giving all-in numbers with a comment or a message, as opposed to breaking down your offer into specific heads of damage. This goes back to my earlier recommendation about avoiding too much focus on legal positions and focusing instead on the goals and the needs of the parties. So by giving a breakdown, the parties often get entrenched in positions on individual issues. Well, an all-in number really allows the plaintiff or the claimant to imagine allocating the funds to those things that are truly important to them. You might also, so just as an example, I might make an offer of $379,655 with a message that the incurred attendant care has been significantly lower than the Form 1 amount that they are using in their offer. But I wouldn't necessarily specify how much of that $379,000 is being allocated to IRB, attendant care, med rehab. There will be other factors and amounts involved in or included in that number, and it will leave it to them to assess if $379,000 is the right number for them to settle this file. This isn't always possible, but I think that you'll be surprised if you make an all-in offer and give a message that it usually does work. You'll occasionally get pushed, but it usually does work. I might be cynical, but I suspect that settlement funds are rarely used for the things that are being discussed in the course of settling a file. So tip number 5. Always keep the midpoint between the offers in mind. So as I've said, the goal of settlement negotiations is to bridge the gap between two positions. Sometimes the parties have assessed the claim similarly and you're able to find common ground relatively easily. However, more often the starting positions are usually quite disparate, and the midpoint at the outset between the offers is not necessarily an accurate predictor of where the file should or will resolve. However, one way to make sure that your negotiation is heading in the right direction is to track the midpoint between the offers being exchanged. And ultimately, the midpoint can also be used to close the negotiations. So I think the easiest way to demonstrate this or explain all of these concepts and bring them together is to use an example. So these are the offers on a challenging back and forth negotiation that I was involved in. So in this case, the client and I had done a fair and accurate assessment of the insurer's exposure and we had assessed the total exposure on the file somewhere between $39,000 and $62,000. And my client wanted to try to settle the file for $55,000 or less. We requested a proposal and got an initial offer of $135,000, which was higher than we expected it to be. In considering our first offer, we knew that there was no offer we could make that would result in a midpoint of our target range of about $55,000. So we made a principled first offer, so not too high and not too low, based on our exposure analysis of $23,456. This put the midpoint between the initial offer and our counter at $79,228. So obviously the initial midpoint was much higher than where we wanted to end up. Primarily because of the significant differential between the two offers. But this is not uncommon at the beginning of settlement negotiations. We did not let this deter us. And the plaintiff ended up making a counteroffer of $125,000. Well, we initially considered a jump to a little bit over $30,000. We realized if we did that, the midpoint between the two offers would still stay in the range of $79,000. So instead, at this point, we opted for a smaller increase of only $1,500, which represented essentially an additional 3 months of income loss, bringing our offer to $24,956. This reduced the midpoint from $79,000 to just about $75,000, as you can see there on the screen. This was a sensitive point in the negotiation because obviously the increase in our offer had been very small, and there were issues with the first offer that became apparent and that we wanted to address. So With some discussion, we were able to get opposing counsel to continue to negotiate. That was the first thing that we had to do, and to essentially drop a head of damage, which was just unsustainable in the dispute. So I suspect they had added it to their number to give them room to negotiate. And they ended up making a much more reasonable offer of $95,000. We decided to reciprocate with a slightly bigger jump to $33,000 at this point because of the drop in their offer, we were able to reduce the midpoint to $64,000, even with making a slightly higher jump in our number. So we were getting closer. We continued in this fashion, watching the midpoint for several more exchanges that you'll see there on the screen, never letting the midpoint go up. So although it didn't happen in this case, in some cases, you may even get to a point where the midpoint is lower than your target settlement range. Once we got to the midpoint in this, or close to it in this negotiation, we considered proposing a settlement in the middle ground. It's important to use your judgment at this point because you don't want to rush after getting this close. And while the midpoint might be in the range that you want it to be, the offers might be far enough apart at this point still that it will be too much of a jump for a claimant to accept. So in this case, when we got to the point that the midpoint was in the range that we were looking to settle in, I proposed to opposing counsel that we both recommend $50,000 to our client. I knew that that was a little bit less than the midpoint, but what I wanted was for counsel and the claimant to feel that they had won by getting that last little bit of money on the table. So counsel actually came back and offered or recommended that we both recommend $55,000 to our client. Of course, my client agreed, and we ended up settling the file at $55,000. Well, this was all of the authority I had in this case, and that the client, it was at the top end of where they wanted to settle. They considered it a big win because we had started so far apart. I will say that the very end of this negotiation was assisted or sped up slightly by the fact that we had a pre-trial pending in the very near future. So sometimes that element of timing, that was a case where that came into play. So in summary, we were prepared. We got a proposal from the claimant. We made a principled offer, which may have appeared to be extreme because of the differential between the initial offer and our offer. But in fact, it was the claimant who had made an extreme offer in this case. We didn't let that deter us. We kept the midpoint in mind throughout the negotiation, and we didn't rush the process until we got to the end. So as you can see, it took several back and forths, and this mediation took, a few minutes every other day for a few weeks. But in the end, we were able to bridge that huge gap at the beginning, and we settled the case before the pretrial, which ultimately saved everybody time and money. So those are my 5 tips. If there are any questions on any of those concepts, I'd be happy to answer them for you now if you put them in the Q&A, and I see that there is one, so let me just have a look. So the question is, we have a plaintiff's counsel who always starts at the limits minus anything that's been paid to date, and decrease in small increments when our assessment is, relatively low. In this particular scenario, apparently $5,000 to $8,000. So it's fair to say, is it fair to say that the plaintiff's legal, that we're too far apart and we should obtain additional medicals to support their assessment, or that they should? Certainly, I mean, again, you do run out of room, I guess, if you're that far apart. And so I would suggest that, particularly if you have an event coming up, that you always leave yourself a little bit of room to make an offer. For example, at a case conference, like I wouldn't want to be offering all of the authority that I had prior to a case conference. You always want to have a little bit left, because the adjudicator might push you to make an offer, and you want to have room to do that. But you know, I'm not suggesting you can always resolve files. I mean, it just doesn't sound like that case is going to be very amenable until people start getting more realistic. I've got a request for the PowerPoint, which I'll be happy to send along. And if anybody else wants the PowerPoint, you can put it in the question and answer, or you can also email me directly and I will send that to you. While we wait to see if there's anything else, let me tell you about our next upcoming webinars. So our next two webinars are going to be vacancy exclusions. And the water's on, but nobody's home. That's on August 26th with my partner, Tim Gillibrand. And the next webinar after that will be on September the 15th, pre-discovery productions, what gets produced and who pays, with Lindsay Rodenberg. Let me just look. There are a couple of more questions, although we are at the half hour. So I will respond to those questions directly and talk to you about your negotiation situations. Thank you, everyone, for attending. Enjoy the rest of your day.